you can't make your happiness contingent on getting a libertarian society. The struggle for liberty will never end because there's always going to be status. There's always going to be people who prefer security over liberty because that's another part of natural instincts that people have. And so the best that we can ever accomplish is keeping liberty alive. And you can keep liberty alive just by being a libertarian yourself.
Hi, this is Damon Root for Reason TV, and I'm here today with Randy Barnett, a law professor at Georgetown Legal Center, and also one of the attorneys and legal architects behind the constitutional challenge to the Patient Protection and Affordable Care Act, also known as Obamacare. Randy, thanks very much for joining us today.
Great to be here, Damon.
So obviously we have the decision in the healthcare case. You're one of the attorneys for National Federation of Independent Business, arguing against the constitutionality of Obamacare. The law is upheld. Chief Justice Roberts upholds the law. Now, you wrote in the Washington Post just a few days after the decision came down, we lost on health care, but the Constitution won. Now, what did you mean by that?
Right. Well, we lost in our effort to end Obamacare, which is really what we were trying to do. We brought the action against the mandate for two reasons. One is, as a leverage point, our only constitutional leverage point to defeat Obamacare generally. And the second is because the theory by which the mandate was enacted, if it had been affirmed by the courts, would be a very dangerous theory. In fact, it would end the idea of limited and enumerated powers of Article 1 of the Constitution. So we're really fighting for both against Obamacare and for the Constitution. And what I was pointing out in that Washington Post piece is that we lost in our fight against Obamacare, although in a moment I'm going to explain why we may not have lost as badly as some people think. But we won in our challenge, in our effort to preserve the Constitution, and in fact we moved the ball in a positive direction.
The Wall Street Journal editorial page, I think, speaking for lots of conservatives, also, some libertarians, said that Roberts substituted one unconstitutional expansion of government power for another, and said that Roberts gave this vast new taxing power. So is that editorial wrong? Are they overly negative about the decision?
Their punchline is right. He did substitute one unconstitutional version for another, but what he ended up doing was somewhat cleverly, although I don't admire it, is that he substituted a much less dangerous unconstitutional principle for a much more dangerous one. That's exactly the reason why this was a pretty big, important victory. What the justification for the law was supposed to be was the Commerce Clause. That's how the law is written, as a regulation of commerce, and if Congress can regulate you when you're not doing anything, that is a huge expansion. And in fact, the theory under which that expansion is justified is essentially that Congress has the power to address all national problems. It's as though we have a national problems clause in the Constitution. And that's what most law professors actually believe. And if that were true, that would be the end of the enumerated powers scheme. What Chief Justice Roberts substituted for that in what he called a saving construction, in which he admitted was not the appropriate reading, not the best reading of the text. Right. Was a tax power, but not the tax power that law professors had been advocating. Law professors said that, oh, well, you could just do this whole thing under the tax power. If you just called it a tax, it'd be the same. But that's not what he did. He said, well, it's written like a tax. If you take the requirement out, first of all, you got to take the requirement out. There was a requirement that everybody buy insurance. Well, you got to take that out because that's unconstitutional under the Commerce Clause. So you take the requirement out. What you're left is with the penalty, and the penalty, he said, is so low that it could actually be a tax and not a penalty. So he really made a distinction between a penalty and a tax. He said the mandate was not a penalty because it was so low. If it had been higher, it might have been a penalty and it would have been unconstitutional because it would be coercive. So what he really said is that Congress can tax inactivity as long as those taxes allow people to make a choice. But if that monetary exaction, he said, ever got so punitive that it would be coercive, in that case, it would be a penalty and it would be unconstitutional. He implied it would be unconstitutional. That wasn't before him. So he substituted a less dangerous tax power for a far more dangerous Commerce Clause power. If the Commerce Clause power had been upheld, not only would the enumerated powers scheme have gone away, but Congress could have changed the law to punish this or any future mandates by very extensive penalties, like high fines and even imprisonment. One last way of explaining the difference. Imagine that all the drug laws were justified under the tax power and not under the commerce power. All the drug laws we have are Commerce Clause power. But imagine they were only justified under the tax power, under the principle that Chief Justice Roberts identified. That would mean that the only thing the government could do to you for violating drug laws would be to charge you a reasonable, modest tax. They couldn't even charge you a punitive tax, and they certainly couldn't put you in jail. If we actually achieved that reading of the drug laws, it wouldn't be a perfectly libertarian solution, but you'd have to open up the jails and let millions of people out under that reading of the Constitution.
The word unprecedented has been used a lot.
I invented that word. I invented it.
I hope you're getting royalties every time it's used. But it seems to me, and you've argued this, that Roberts' opinion is quite unprecedented because he's putting forward an argument that we haven't really seen before. I mean, is that correct?
Yeah, it's absolutely correct. He appears to be the only person in the United States, and certainly the only legal commentator, who holds the view that he announced last week. And that is this view that the Commerce Clause makes the mandate unconstitutional because it mandates inactivity. It compels commerce in order to regulate it. That's unconstitutional. Therefore, we have to adopt a saving construction to eliminate the requirement, and the penalty can be justified as a tax, which can't be more than a reasonable amount. That is unique to him. No one's ever identified that view before. No one who supported the mandate, no academic who supported the mandate has held that view. No judge who's considered this case has held that view. No other justice holds that view. This view is unique to Chief Justice Roberts, and it was unknown until he announced it. And that should tell you something about whether it was a legally compelled outcome. Because if this was the obvious best legally compelled outcome, someone would have held it before, and no one did.
So if it's not a legally compelled outcome, what's the explanation for
well,
this?
It's circumstantial evidence that this was a politically compelled outcome. And in fact, I'm not exactly sure why that would even be so controversial to say, since all the people on the left, from the president to the chairman of the Senate Judiciary Committee on down to columnists like Jeff Rosen, were urging Chief Justice Roberts, sometimes in particular, to save the legitimacy of the court by not going along with a 5-4 conservative liberal decision striking down the president's signature legislation. Well, everything I just said in this sentence are political considerations, none of which relates to the Constitution or even to Supreme Court doctrine about the Constitution. It all relates to political considerations, and if those were the considerations urged upon him that persuaded him to cop out in the way he did, then that makes it a political decision. But I want to be clear about one thing. It's not like I'm saying that it was a political decision in the sense of the 5 justices who voted to uphold Obamacare were acting politically. What I'm saying, I think 4 justices were acting in principle. They have a principled view that there's a national powers clause in the Constitution. That's their principled view. And then 4 justices were acting in principle against that view. 1 justice, the swing justice, his view was the one that was possibly motivated politically.
Let me read you a passage from Roberts' opinion. He said, "It is not our job to protect the people from the consequences of their political choices." I mean, that's, what's wrong with that? That's sort of like the classic argument for judicial restraint. We have a presidential election coming up. Right. Why not just take it to the ballot box?
I mean, that's exactly wrong. It is the court's job to protect the people from the consequences of their political choices when they violate the Constitution of the United States, which is a higher law, also enacted by the people, to check Congress and the other branches of government. The Constitution is the law that governs those who govern the people, and it was put in place by the people. So the people who are supposed to be bound by that law, which is the Congress and the courts and the president, they can't change it to make it more suitable to them. It's the court's job to follow the Constitution, which is the higher people's law. And so it is very much the job of the court to protect the transient will of the people, assuming even, by the way, that Obamacare was part of the will of the people, which the only evidence for that is it got a bare majority of it got a bare majority of Democrats. It got the requisite number of Democrats to vote for it. That's the only evidence that it's, quote, the will of the people. And it is the job of the court to protect the people when they were acting in their sovereign capacity of enacting a constitution from that.
I want to go back to the Commerce Clause part of the case for a second. So the Chief Justice accepts your arguments entirely, that this is an unprecedented exercise of congressional power under the Commerce Clause. And then for dissenting justices...
And let me just interrupt you. It's unprecedented. The courts are empowered to enforce it, and the individual insurance mandate violates it. He said all 3 of those things. That was our whole case.
So we have 5 justices who accept your arguments entirely. So Is that a binding ruling? Is that I've seen legal commenters say, well, that's just dicta. That's not something that binds future courts or lower courts. But what's your view?
Well, it's a dicta holding distinction is a technical distinction in law, and there's, I would say, for purposes of this interview, two different ways of looking at it. Sort of the technical way, and that is, were there 5 votes? Were there 5 justices in support of the opinion of the court, which identified what the holding was? And it turns out that there were. It turns out that the liberal justices signed on to Part 3 of Justice Roberts' opinion, in which he said that the holding of this court is that you cannot be compelled into activity under the Commerce Clause, and so we're going to do this saving construction instead. It says the court holds this, and 4 liberal justices signed on to that part of the opinion, so it has 5 justices that makes it the holding of the court. That's one way of looking at it. The other way that's really, in some and that's the way that is pertinent for lower courts. In terms of future Supreme Courts and the general public and the public generally, the other way of looking at it is pragmatically. Are there 5 votes to uphold something? If you went to a district court judge in the future, would a district court judge look up at the Supreme Court and say, are there 5 votes for drawing a line in Article 1 and saying Congress can't go that far? Well, clearly there are. So if you just look at it doctrinally, or if you look at it pragmatically, it's the holding of the case.
One of the criticisms that I know that you've received and the legal challengers have received is that this case, that your arguments they were going to overturn the New Deal, they were going to bring America back to the horrors of the Gilded Age and a return to Lochner and so forth. But in fact, if you actually read your briefs and your arguments, they were based entirely on the idea of precedent, and that this was a case of first impression, and that the Supreme Court had never allowed something like this before. So having said that, so if the arguments are crafted to the specific facts of the case and to the unprecedented nature of the individual mandate of Obamacare. So if the mandate is then upheld under other grounds, are there other practical benefits aside from the lower courts looking up at the 5 justices?
It's really funny, Damon. I mean, for 2 years, I've been hearing if Barnett's view or the challenger's view is accepted, it's a threat to the entire post-New Deal apparatus, and it's a return to the bad old days, et cetera, et cetera. And I've been denying this. I've been saying that it would apply, that if we win, it'll apply to one law that's ever been passed, the Affordable Care Act, the individual mandate, because it's the first time Congress did this, and it'll leave, as you say, we haven't challenged any precedent. It will leave all precedents in place. It will leave all laws in place. It will actually be a very limited victory. The day after the opinion is issued, I'm hearing liberal commentators like Jeff Stone, former dean of Chicago Law School, saying, this is actually a very limited opinion. It only applies to mandates, and they're probably not going to do mandates again anyway. Exactly what I've been saying all along. All right, so in that sense, it's very limited. However, there's 2 ways of looking at it. First of all, had we lost, it would not have been limited. Had we lost, we would have had a national problems clause in the Constitution, and Congress would have had the power that all law professors want it to have, which is the power to do anything it wants with respect to the economy. They clearly were refuted. I mean, the view that 99% of law professors hold today could not command 5 votes at the Supreme Court. It got 4 votes at the Supreme Court, and it could not command 5. That's huge. That's huge. But even more so, it basically says, as I was saying before, the Commerce Clause has limits. The Supreme Court will enforce those limits, and here's a third important thing. The necessary and proper clause cannot be used as an end run around those limits, which, by the way, there was much less case law on. That was, in some sense, the doctrinally weakest part of our argument, which we had some case law, but the Supreme Court said very little about the necessary and proper clause. We argued that even though the Supreme Court is deferential, for your listeners, the necessary and proper clause says Congress shall have power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. The Supreme Court's been very deferential about what's a necessary law. They basically defer to Congress. And a lot of people have claimed that the word proper doesn't do any independent work. Our theory was based on the idea that proper is separate from necessary, and this was, however necessary this law was to the Affordable Care Act, it was an improper means. Most law professors, most legal authorities rejected that idea. In fact, there's very little authority one way or the other on that. We had some, for example, the Prince case that said commandeering state officials is improper. But anyway, this case made fantastic law. Chief Justice Roberts said specifically that the mandate was an improper means under the necessary and proper clause for enforcing executing the Commerce Clause. So what our contention on the necessary and proper clause was also there. And in terms of what this means for the future, The future depends on what future justices want to do. Let's be realistic. I mean, I've been realistic from day one. Sure. Let's be realistic. It all depends on what future justices want to do. Number one, if future justices want to protect the enumerated power scheme, they won't have a super bad precedent standing in their way, which they would have if we had lost on the Commerce Clause. And number two, they've got a tremendous precedent for the idea that the enumerated power scheme means something and is legal and judicially enforceable. The necessary and proper clause is also a constraint, or it's not a blank check for government, and that's a huge accomplishment.
We've talked largely about the Commerce Clause in this interview, so I want to ask you about the spending power part of the ruling,
Sure.
which has not gotten as much attention, but also that's also something you can consider a victory for your argument.
It's a huge victory. No one thought, in fact, I didn't think, that we had a chance on that. In fact, I'm sure that Paul Clement, who argued the case, was surprised that cert was even granted on that, and separate argument was devoted to it. And we actually won on that. There's never been a case before. There's never been a case since the New Deal where the court found any restriction on the spending power. And the spend is actually not in the Constitution. There's a power to tax, which presumably includes the power to spend the money that you get from the taxes. And there's been no judicial limitation on that at all. There was a case, 20 years ago that said that, if the states were coerced, if threatened to have funds withheld that would coerce them, then that might be unconstitutional, but it wasn't in that case, which involved 5% of highway funding. And no lower court had ever found that line had been crossed. Well, the Supreme Court found that line had been crossed, 7-2. Mm-hmm. The vote was 7-2, that there was a line on the spending power. It got crossed. And then the remedy for that, which is again more than we expected because we didn't expect to win on this claim at all, is that with respect to these Medicaid funds, the Congress cannot withhold money for the existing Medicare program in order to get the states to agree to an expansion of that program, a substantial, really big expansion of that program. Agreeing to minor changes is one thing. A whole new thing is another thing. And they can't leverage the money they're spending on existing programs to make them do this or coerce them into doing this other one. This is a huge victory also.
What's your sense of why there was the sort of the liberal legal establishment was just so overwhelmingly opposed to these ideas and just seemed to think that the idea that the Commerce Clause posed any sort of limitations on congressional power was just something that was just foolish?
This is a really important question. Since the New Deal, liberal academia, and there is almost no diversity in liberal academia. It's a complete echo chamber where they basically talk to each other. Liberal academia has maintained that the New Deal court's jurisprudence and the Warren Court's jurisprudence stands for the proposition that Congress has a national problems power. They have the power to solve any national problems, and especially national problems that pertain to the economy, which is, when you think about it, everything. That's their view. That's what they think the New Deal stood for. It's not what the New Deal court ever said. It's not even what the Warren Court ever said, although the Warren Court took it a little farther than the New Deal court. And so, but they've been teaching it this way for 70 years. That's why in 1995, when the Lopez case found a limit, they went berserk. They went berserk. And now the Lopez is hallowed precedent that they use to show, they believe in limits too. Look at Lopez. But at the time, Lopez was conservative judicial activism because it found any limit at all, because it violated their fundamental belief that there were no limits. And so they dismissed Lopez as being not serious and symbolic, and all Congress has to do is clean up its findings and the court will break. Then in the Morrison case, the violence against women case in 2000, when the court again held the line and found something unconstitutional, then they got scared and they thought, wait a second, maybe the court's serious and maybe we were wrong. And lower courts actually started operating then. And then in 2005, in the Raich case, which is the case on behalf of Angel Raich and Diane Monson that I represented them in the Supreme Court, all the way up to the Supreme Court, when they upheld the law in Raich and Justice Scalia and Justice Kennedy crossed over and joined the liberals in upholding the application of the Controlled Substance Act to what marijuana you grow in your own backyard to consume yourself, they breathed a sigh of relief. They said, we were right all along. This little blip of new federalism is nothing. Maybe it's a little symbolic thing, but otherwise it's nothing. We're back to our default position that Congress has unlimited power. When we made our argument now, 7 years later, they were already back in their original position, and we were arguing there's a limit, and they said, that's crazy. That's crazy. That violates everything we know. Now, I mentioned the liberal echo chamber. I think that's in academia. I mean, on the Georgetown faculty, where I'm very welcome and very well treated, and I really am happy, we have about 110 faculty members, of which 3 are identifiably right of center. And when you and that makes us more diverse than most elite law schools. And when you live in an echo chamber like that, it's okay to let somebody like me in, but I can then be dismissed as an outlier because I'm alone. It's, you know, so there you have the diversity of hearing what I say, but because it's 99 to 1, in academia generally, it's actually worse than that. It's probably 1,000 to 1. Well, something like that. But because it's like that, they can say, well, you guys, you may be, we hear you, but we don't have to take you seriously.
Is that something that's going to change?
I don't know. I hope it will. I have a new center at Georgetown called the Georgetown Center for the Constitution that's gearing up this fall. One of its missions is to bring fellows in who might go into teaching, and other institutions are doing similar things. There's other institutes doing that. It's going to be a long process because, in fact, the bias against libertarians and conservatives in academia is overpowering in law schools and in law schools in particular. Although I will say that there's a greater bias towards conservatives than there are towards libertarians. Libertarians are considered kind of, you know, safer or something, a little more interesting, you know, and conservatives are more out there. So there's more bias against them than us, maybe.
I imagine that a lot of people who watch this video will be law students who read your work and are interested, or even maybe high schoolers who are interested in the Constitution and these legal issues.
Yes.
I mean, what would
Good for you.
What would you say to them? I mean, what would you say, you know, is it's if they're thinking about maybe a career in law or just want to work on constitutional issues?
I'd say it's the best career I can possibly imagine. And even being in the minority has its advantages, big advantages. For one thing, you're always saying things different than everyone else. I think it would be a bigger challenge to be in the 99%. There's a different version of the 99%. We're in the 99% because you got to think of something different to say when you're basically saying the same thing as everyone else. I never have a problem thinking of something different to say, so it's really interesting. You're not badly treated at all. I'm treated very respectfully. Whenever out of the blue, when something actually disrespectful happens, it's so unusual that I'm taken aback and I'm not even sure how to respond to it. If it happened all the time, I'd have defense mechanisms all in place. And I think that's partly if you treat other people respectfully, they treat you respectfully back. And the other part of it is that, you know, because there's this immense discrimination, we have to be better, really, than our peers to get ahead. And so wherever we are, whatever station we are on the ladder of success, you know, we are somewhat better than our immediate peers because we had to be to get that job, and therefore we do pretty well. It's a fun life. It's a great life. And I think the thing I tell libertarians generally about this, not just academics or prospective academics, is that, you know, you can't make your happiness contingent on getting a libertarian society. The struggle for liberty will never end because there's always going to be statists. There's always going to be people who prefer security over liberty because that's another part of natural instincts that people have. And so the best that we can ever accomplish is keeping liberty alive. And you can keep liberty alive just by being a libertarian yourself and writing about it and, you know, getting other people to be. Even if the society you live in is not, you can at least keep the idea of liberty alive and possibly liberty itself.
You're also known as an exponent of originalism.
Yes.
Or original public meaning originalism.
Yes.
And so I wanted to ask you about that, but also that you have a section in your book, Restoring the Lost Constitution, originalism for non-originalists.
Right.
So I wonder if you could just run down that argument.
Well, I wasn't an originalist for a long time, and so all the early years I was working on the Constitution, and at some point or another, because I was talking so much about the original meaning of the Ninth Amendment and so much about the original meaning of the Second Amendment, which is another amendment I got into early on, I started to have cognitive dissonance. Why am I talking so much about original meaning if I don't think originalism is right? And then just by happenstance, I mean, this was just totally weird. I was teaching a seminar on the Constitution, and there was a footnote to a book by Lysander Spooner called The Unconstitutionality of Slavery, which was published originally in 1845, long before the Civil War, long before the 13th Amendment. And I looked at this footnote and I thought, what the heck could this be? I know Lysander Spooner, but what's he talking about? I didn't know he did anything other than no treason, and so what's this about? So I had the library get me this, and it turns out it's a 280-page book that was published in 1845 about why the Constitution doesn't sanction slavery. And the method that he used was the method that has come to be known as original public meaning originalism. And I had not seen that as a form of originalism articulated before. It turns out, in a parallel track, others had been moving in that direction unbeknownst to me. Justice Scalia, for example, had already moved to original public meaning originalism from original framers' intent originalism, which is what I rejected. But I got there through Lysander Spooner, and then I worked that up and eventually found out other people were doing similar things, and then I kind of threw myself into that position.
You bring up Lysander Spooner. I was going to ask you then about, because you've been doing work in the last couple of years on the abolitionists and on the 14th Amendment.
Right.
So did Spooner lead you to study the abolitionists more broadly?
Absolutely. I didn't know anything about that. And all I knew for many years was Spooner's work. And I was writing a book on the 14th Amendment, which I'm no longer writing, because I got stuck on the chapter on the abolitionists. My thesis was going to be the abolitionists are going to be the key to the 14th Amendment, and I got to the chapter on the abolitionists. I ended up taking 2 years just studying them. And what I discovered is something that some historians know, but no law professors know. And the historians don't appreciate the legal significance. They just know these people existed. There really were two camps of abolitionists. There were the radical abolitionists under the Garrisonians, and they were anti-political. They were called disunionists. They actually wanted to withdraw from the Union, and they were anti-political activity. And most of them became anarchists. And because they had the argument that their argument against slavery is no person can rule another, and if they took that principle and they applied it to government, they said, well, no person can rule another, so we're anarchists. And that's one camp. But there was this other camp that's not known to be a camp of abolitionists. And one word that's used to describe them is constitutional abolitionists. They believed in political activity, and they believed that the Constitution actually was not pro-slavery, it was anti-slavery, and they pursued political action in order to end slavery. They founded initially the Liberty Party, which was a single-issue anti-slavery party. Then they went on to found the Free Soil Party, which was a more moderate vision of this view, and eventually they formed the Republican Party, the constitutional plank of which said that the Constitution does not endorse slavery, it just allows it in the states that had it, and it was the constitutional commitments of the Republicans that drove the South out of the Union and ended slavery by means of a war. But let me just mention Spooner here. Spooner, very interestingly, was in both camps. Right. He was an anti-political guy, but he kept and so he wasn't a fan of the Liberty Party and political action, but he kept those views quiet because he didn't want to alienate his audience, because he had a lot of fans in that camp because he was a pro-Constitution guy. So he was in neither camp. He was against the Garrisonians' anti-constitutionalism. He was against the political activity of the constitutionalists, and as a result, both sides actually respected him quite a bit, especially the constitutional abolitionists. He was kind of a hero, an intellectual hero to them.
And he was also a big influence on Frederick Douglass. Douglass credits him for his own anti-slavery reading of the Constitution.
Yeah, Douglass was a complete Garrisonian. In fact, when he first heard the Spooner views, he said, that's just making it up. That's just, you can't read your own views into the Constitution. And then shortly thereafter, he was persuaded by it, and from then on in, he was one of the most articulate advocates of the idea that this Constitution is not pro-slavery.
And what can the abolitionists teach us today? I mean, obviously you're very interested in this. You're doing a lot of research on it. I mean, are there lessons for the law today aside from the original meaning, or is that the main?
Well, no, I think that they can teach a lot of things, but for purposes of this interview, the reason interview, I think the abolitionists are the original intellectual origins of modern libertarianism. I think modern libertarianism can be traced back to the abolitionists. I mean, and Spooner is in some respects one of the principal links there, because he takes you all the way up to the end of the 19th century, and the people he's hanging out with are the precursors of the modern libertarians. And in the abolitionists, you see the modern libertarian movement's sort of schism, although I think it's a soft schism, between the more radical anarchistic type libertarians, which are the Garrisonian types, and the constitutional libertarians, who believe both in political activity to try to advance liberty, and they believe that the Constitution is a means for doing so. They believe both those things. I think if you look back at what was accomplished then, it was the constitutional abolitionists that actually ended slavery. Now, I think a critique can be made of what we got in its place in terms of a national government. I understand that. I share that view in large measure. But they did get slavery done with, and the Garrisonians, but the Garrisonians played an important role in that too, because they made the moral case for it in a way that appealed to a lot of other people. So look, you had them both sort of working in tandem with each other, critiquing each other, but really on the same page. They were on the same page, and I don't think it's any coincidence that the constitutional abolitionists called their anti-slavery party the Liberty Party. And I just think that's where we come from, and we ought to rediscover those roots. We should be proud of them.
I'm going to read you a quote. This is Justice Oliver Wendell Holmes, 1905, a very famous dissent. He said, "The Constitution does not enact Mr. Herbert Spencer's social statics." Now, obviously, Spencer, he's not so well known today, and to the extent that he's known, he's sort of misunderstood, but maybe we could update that as, the Constitution does not enact, the libertarian principles of Reason Magazine or the libertarian principles of Randy Barnett. But you've addressed this question of the Constitution's compatibility with libertarianism, or at the Cato Institute a few years ago, you gave a speech as the Constitution libertarian.
Right.
So what's the answer?
Well, Holmes is wrong about this as he was wrong about almost everything. He's one of my least favorite judges. I mean, he was, by the way, a eugenicist. He was a social Darwinist. So he's the opposite of a hero of mine. He's wrong to think it's consistent with all political theories. And if it were true that it was consistent with all political theories, you wouldn't have to have a living version of it that leaves out whole parts of it. Why did they cut out the Privileges Immunity Clause? Why did they cut out the Ninth Amendment? Why did they limit, the Commerce Clause is making a comeback, but why was it, why were all these parts gone? Because they got in the way. Right. If they didn't get in the way, you could just use them. But you got to get rid of them because they're in the way. You can't have it both ways. You can't say the Constitution we have is consistent with all political or all legislative ends, all laws, and then get rid of the ones that get in the way.
So the Constitution is compatible with libertarian principles?
It's compatible with them, and it actually is what has kept us a freer society. I mean, the other way of looking at the Constitution is that one of the reasons why Spooner eventually turned away from the Constitution, which he did later on, was he said, look, the Constitution either gave us the kind of tyrannical government we have, or it was incapable of preventing it from taking place. And I'm very sympathetic with that view. I was completely sympathetic with that view years ago. I'm less sympathetic. I'm still sympathetic, but I don't buy it entirely, because I think one of the reasons why we have as free a society as we have is because of what's left of the Constitution. Here's a way of thinking of it. The founders built a Constitution that was so well engineered that it built in so many redundant checks on power that even if you get rid of this one and this one and this one and this one, just the ones that are left are enough to keep us relatively free. It's as though you're on a 4-engine jet. You've lost 3 of your engines. The last remaining engine is still keeping you aloft because the jet was well designed. It was designed to fly on one engine, although that's not optimal. And that's where we are now. We're flying on one engine. What's left of the Constitution, it's still good enough to keep us aloft. But it would sure be a lot better if we could get all the other engines fired up.
Well, that's a great place to end. Thank you very much, Randy Barnett, professor at Georgetown Law Center, one of the legal architects of the challenge to Obamacare, and the author of many great law review articles and books. Your personal website, randybarnett.com. You also blog at The Volokh Conspiracy. Everyone should check it out.
Thanks, Damon.
Thank you.
Problems clause in the Constitution, and that's what most law professors actually believe. And if that were true, that would be the end of the enumerated powers scheme. What Chief Justice Roberts substituted for that in what he called a saving construction, in which he admitted was not the appropriate reading, not the best reading of the text, was a tax power, but not the tax power that law professors had been advocating. Law professors said that, oh, well, you could just do this whole thing under the tax power. If you just called it a tax, it'd be the same. But that's not what he did. He said, well, it's written like a tax. If you take the requirement out, first of all, you got to take the requirement out. There was a requirement that everybody buy insurance. Well, you got to take that out because that's unconstitutional under the Commerce Clause. So you take you can't make your happiness contingent on getting a libertarian society. The struggle for liberty will never end because there's always going to be statists. There's always going to be people who prefer security over liberty because that's another part of natural instincts that people have. And so the best that we can ever accomplish is keeping liberty alive. And you can keep liberty alive just by being a libertarian yourself.
Hi, this is Damon Root for Reason TV, and I'm here today with Randy Barnett, a law professor at Georgetown Legal Center, and also one of the attorneys and legal architects behind the constitutional challenge to the Patient Protection and Affordable Care Act, also known as Obamacare. Randy, thanks very much for
your theory. In fact, it would end the idea of limited and enumerated powers of Article 1 of the Constitution. So we're really fighting both against Obamacare and for the Constitution. And what I was pointing out in that Washington Post piece is that we lost in our fight against Obamacare, although in a moment I'm going to explain why we may not have lost as badly as some people think. But we won in our challenge, in our effort to preserve the Constitution. And in fact, we moved the ball in a positive direction.
The Wall Street Journal editorial page, I think, speaking for lots of conservatives, also, some libertarians, said that Roberts substituted one unconstitutional expansion of government power for another, and said that Roberts gave this vast new taxing power. So we're joining us today.
Great to be here, Damon.
So obviously we have the decision in the healthcare case. You're one of the attorneys for National Federation of Independent Business, arguing against the constitutionality of Obamacare. The law is upheld. Chief Justice Roberts upholds the law. Now, you wrote in the Washington Post just a few days after the decision came down, "We lost on health care, but the Constitution won." Now, what did you mean by that?
Right. Well, we lost in our effort to end Obamacare, which is really what we were trying to do. We brought the action against the mandate for two reasons. One is, as a leverage point, our only constitutional leverage point to defeat Obamacare generally. And the second is because the theory by which the mandate was enacted, if it had been affirmed by the courts, would be a very dangerous.
Is that editorial wrong? Are they overly negative about the decision?
Their punchline is right. He did substitute one unconstitutional version for another, but what he ended up doing was somewhat cleverly, although I don't admire it, is that he substituted a much less dangerous unconstitutional principle for a much more dangerous one. That's exactly the reason why this was a pretty big, important victory. What the justification for the law was supposed to be was the Commerce Clause. That's how the law is written, as a regulation of commerce, and if Congress can regulate you when you're not doing anything, that is a huge expansion. And in fact, the theory under which that expansion is justified is essentially that Congress has the power to address all national problems. It's as though we have a national